What's up, co-counsels? I'm coming with low energy today. I had a long day. All right, I had a long day. I got the chance to watch Jennifer McCabe's direct testimony live. I watched most of it. There are a few parts that I missed because obviously I'm not glued to my desk. All right, so let us get into it. As far as McCabe's testimony, not increasingly different from her previous testimony. But obviously, having listened to, I forgot her name. Hold on, Carrie Roberts. Having listened to, I believe her first name is Carrie. Having listened to Carrie Roberts just recently, their testimonies line up, as is the case with every witness that takes a stance. Um, it's really cross examination. Okay, cross examination is where they really get tested. But considering that the court did not get into cross examination today, and not defendant, um, Jennifer McCabe is still on the stand and it's still direct. That's what we're going to at least be analyzing this time around. I'd like to believe that we get into cross tomorrow.
All right, Mr. Brennan, whenever you're ready, Mr. McCabe, I'd ask that you pull the microphone close, please. Okay, thank you.
All right.
Thank you, Your Honor.
Go right ahead.
Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury?
What's up, real thing? Real thing. I wanted you here yesterday. Was it yesterday? Believe it was last night when we talked about, I think it's I don't know, my days are off. I had a rough day. But I believe it was yesterday when the defense experts were under voir dire. I think it was yesterday. So real thing says Jan Jan was on her best behavior today. Listen, in the words of Jennifer McCabe, I love it. All right. I cannot wait for cross examination. That's when we really get to see her tested. But let's see. I took some notes. I did not bring out my legal pad because I don't know that there's not much to her testimony. Again, it was pretty similar to Carrie Roberts.
Hi, I'm Jennifer McCabe, MCCABE.
Ms. McCabe, how old are you?
I am 49 years old.
Okay.
Are you married?
Yes, I am married with 4 daughters.
When I first heard this, I thought she actually said 39. I was like, you look kind of old for 39.
Without
Not that it
detailing your
matters.
children's names, can you tell us a little bit about your family?
Sure, I have 4 daughters that are 16, 17, 19, and 21. 2 are in high school and 2 are in college.
All right.
In raising your children, was your family active in local sports?
Yes, all 4 of my daughters played multiple sports from when they were young. 2 now are playing in college. My husband and I both coached them. My husband coached them from when they were young.
What's up, Benji? How you doing? All right. So real thing, listen to the replays. Shout out to the replay crew. Okay. If you have questions, if you want to debate real thing, I'm right here. Okay. If you disagree with me, definitely let me know.
Up through 8th grade in soccer, and I coached them in basketball.
But as far as Dr. Daniel and Dr. Retchenhauer, or whatever his last name is, I think they get to testify. I don't. I mean, if Bev Canoni decided to sanction the defense for blowing the deadlines, it's not out of line. But I do think she's going to let them testify.
Without telling me your address, what town are you from?
I'm from Canton.
How long have you lived in Canton with your family for?
I was born and raised in Canton, and now I'm raising my family there.
So your family, their whole life, you've raised them in Canton?
1 year we lived in Stoughton with my daughter.
Who do you live with now?
I live with my husband and my 4 daughters.
Can you?
So far, all these people's marriages have remained intact. I don't know why they would not be intact, but observation.
Briefly give me a little bit more background on your children's school and your participation in interaction with your children, raising them?
Yeah, so I was a teacher, and then once I had children, I stayed at home with them and basically was just kind of like your typical, I don't know, small town mom.
Again, I'm pretty nosy. I don't remember if we ever found out what Jen's husband does for a living. I don't quite remember. But as I was listening to this in real time, let's move on because I'm I was gonna drift all the way off. I was gonna drift all the way off. So let disregard what I was about to say.
I was the
Sometimes I do have to censor myself because I do get out of control.
room parent. I coached them.
No, I'll allow it, but
And over here, the reason why the defense objected is because obviously through this background information, Brennan is making Jen likable because jurors like to hear about things that folks are doing in the community, and Jen so far seems to be or appears to be selfless in the sense that she decided to give up her career as a teacher to raise her family.
when we
Yes.
move on.
When I coached,
This thing, jurors love talks about sports and dogs, like they like pets. People generally like to hear about pets.
I drove the kids back and forth on my team, would take them places, etc.
In the growth of your family and raising your children, at some point did you meet a gentleman by the name of Donald?
Oh, send me an email. Lovey, I just got home like what 40 minutes ago, so I did not look up anything. Let me actually look into it. Ooh, all right. So real thing says for people that are just listening and not actually watching the screen, real thing says Bev made her decision and it's more than we expected. Do I want any spoilers? Let me find it and then we can talk about it.
O'Keefe.
Yes.
Share with us meeting
That's
John.
the thing. When I come up here early, I suppose I miss out on a lot because I've not had time to look up anything. But I don't know. Tomorrow I'll be early again. We're gonna do 6:30. But let me find Bear Canoni's decision.
O'Keefe.
Sure. When my third daughter was in kindergarten, she became friends with John's niece. And during that kindergarten school year, unfortunately, Kaylee's mother and father both passed
Woo!
away. And John.
Hold on. The headline says, listen, when I came up here, I was tired. Not was. I'm definitely tired. I'm exhausted. But this headline woke me up, baby. It says, woo, hold on. Let's go back. And I'm just getting distracted. So apparently, Bev Canoni told the defense, no more nonsense. Okay. She does not want any more crap, no more nonsense from the defense. Let's see. All right. So this is from, let me see if I can find the actual decision. I don't have enough time. All right, let's just read this, or at least I'm going to read it because, a real thing already knows what's going on. But real thing says Bev verbally announced her decision. Oh, really? She did? Where was I? Oh. All right, I think what happened was because I was surprised. They ended around court ended around 3:55 p.m. Eastern time. And I was like, this is kind of early. I was like, this is kind of let's just fast forward. I was like, this is kind of early. So once Jan McCabe got off the stand, I just assumed that the feed had ended. So I carried on with my work. So let's fast forward to hold on. I don't remember seeing Alessia up there. I don't remember any of this. All right. I might have to edit my title. All right. Let's see. Yeah, once this fan comes up, I just assume that court has come to an end. Apparently not. All right, thanks for that real thing. What's up, Allie girl? All right. Oh, now I'm really excited because I had a long day, you guys. Let me tell you guys something. So I have a lot of phobias, but I have okay, I'm gonna go off on a tangent. So my daughter has a real fear of spiders. Okay, like a real fear of spiders. Usually, it usually it's a spider that might pop up every once in a while, or even if we're outside, like outdoors, and she sees a spider, she's going to freak out. Sometime last year, or was the beginning of this year, I don't remember, towards the end of last year, no, it has to be end of last year because we were on our way to no, we're coming from a dentist. So this is around December, okay? We're again, usually her freaks out on this is going to come back to me, but listen. Usually her freaks out aren't too bad because it's usually in a controlled environment in the sense that I can actually react to it. We've not seen spiders in here in a long time, but every once in a while outdoors you might see a spider, or even if she sees a moth, she's freaking out. So I was driving in snowy roads, okay? Snowy roads. I'm driving. I did not have snow tires at the time because that's before I got stuck on the highway. And this girl started squealing like she was freaking out. And the reason she was freaking out is because somehow when we opened the door. What's up, Brooklyn? A spider. I don't know. A spider was in the car. I don't know how the spider got in the car. This is the first time I've ever seen a spider in the car. But a girl started screaming. I was going through an intersection. Luckily, I still have child lock on because she probably would have opened up that door and just, ran or something. That's how terrified she is. So, coming back to me, if you don't have a phobia, you cannot relate to this story, but people with real phobias, certain things just completely disturb us. So I have a real phobia. I'm not going to tell you guys what the phobia is because, again, the way human beings work, every time I've told somebody what my phobia is, either they send me an email with that mess, or what happened today, one of my colleagues shows up with my phobia, and this is the third time that they've done this. So I was disturbed all day. Okay, I was disturbed all freaking day. But we will leave it at that. All right, let's see. All right, so we have Brooklyn in here. Okay, Real Thing says the entire exchange of Brennan stating his argument, Alessi responding to Judge Bev, and Judge Bev announcing her decision is very interesting and dramatic. That's what I like. So let's get into it. I'm actually going to edit. No, I'll edit this at the end. I'll edit this at the end. All right, let's get into it. Okay, so Benji says, sheesh. And so if they know it's your phobia, then yeah, I think they've been doing it intentionally. And I've just been disturbed all freaking day. And this is the third time. I mean, it's been more occurrences, but I'm thinking of, three separate occasions. And I was freaking, I was in distress. Okay. I don't know why they did that. I guess they're being passive aggressive, or they must really just hate me. Because the first time it happened, I was ready to quit, but I'm like, girl, don't quit because you need to sort out your things first. And then the second time, I was just really annoyed. But today, I'm about done. All right, let's get to the exchange. Let us get to the exchange. And real thing, how did you know that court was not done? Because I mean, they had a ceiling fan on. Or did I miss Bev saying something? I don't know.
We're back in session. You may be seated.
All right, Mr. Brennan, I'll hear you.
Your Honor, in light of yesterday's hearing with the ARCA witnesses, the Commonwealth is going to ask the court to preclude the ARCA witnesses from testifying both about any new testing and any new opinions? And secondly, from testifying.
Okay, so it appears that and again, I'm just analyzing this, but I'm trying to process it, break it down for myself. So it appears that Brennan wants specific aspects of their testimonies excluded, and not, I guess, he's not asking for them to be completely excluded.
About their original opinions turned over in a report prior to last year's trial. To be brief, what we learned or confirmed is that we do not have all of the discovery of communications. There was a court order for the ARCA witnesses to provide Your Honor with all of their information, phone records, text messages, communications about this case. Instead of providing their information to the court, they instead chose to send it to the defense.
That's what really puzzled me about Daniel Wolf's testimony. If you are a doctor and you can read, and the order instructs you to produce documents and evidence to the court, I just don't understand what the confusion is. I don't understand why there was, I mean, I get it. I think there's something nefarious going on, but it blew my mind that that's how they chose to go about it.
And then it was summarized and provided by the defense to the court and to the Commonwealth. It appears to me that is not in compliance with the court's order. What we learned during the hearing yesterday is that Dr. Wolf admittedly destroyed over 100 text messages.
Right.
Now, he mentioned that he changed phone carriers, but then later admitted that he actually intentionally, for no apparent reason, destroyed the text messages in this case. And so what is left for
real thing, I remember, I believe it was a week ago or the week prior, my dates are off, okay? But when I said that I've lost all respect for Alan Jackson, these are the antics that I was referring to. I don't know. Listen, the only thing I take from Fonnie Willis is relationship advice. All right. That's the only thing I take from Fonnie Willis. And I know to celebrate 50 big. Other than that, when we were talking about Fonnie Willis, I said that I could not relate to attorney misconduct because I just cannot relate to this type of behavior. So as far as Jackson, and apparently a lot more attorneys engage in improper conduct, I suppose, again, I don't want to cast I don't want to cast aspersions on any of these people, okay? But I do have serious concerns about how some of these attorneys conduct themselves. And as I'm talking about this, I'm thinking Fonnie Willis. I'm definitely thinking about Alan Jackson because this is the case that's a case of bar. All right. I'm also thinking about, again, we cannot forget the YSL trial. I'm thinking about Joe Takapina. I have concerns. I have serious concerns, and I would like to believe that this is not a representation of how. I mean, I guess it's it might be a microcosm of how some attorneys conduct themselves, but I'm highly disappointed.
Honor to look at is a summary of phone records from the defense and ARCA's information that is passed through the defense to the court. You do not have the text messages. You do not have the content of the text messages. There is no summary of the conversations, dozens and dozens of calls between the defense and the experts. It is difficult to believe that all of those text messages and all of those phone conversations dealt with simply logistics. In fact, we later learned during the
here's the thing, something just came to mind right now. If there's a mistrial in the second trial, I would like to believe that the Commonwealth, because during the lunch show, or the lunch break, or whatever it is that they call it on Law and Crime, apparently, what's her name? Let me think. Angelique, I think that's her name. I think it's Angelique Levy or something along those lines. She watched a documentary of like Karen Reed documentary, and friends of John O'Keefe were interviewed, and apparently the information that they got from the DA's office or the Commonwealth is that if there is in fact a mistrial in this second trial, the Commonwealth will keep bringing this trial, or they'll keep retrying Karen Reed as many times as it takes. And just now it popped in my mind because, again, when it comes to cell phone data, when people delete information, they think it's completely lost. That's not how it works. I once worked on a case. This was a crazy case. We're not even going to get into the facts because it was very disturbing, really disturbing stuff. But in any event, somebody got murked, um, and it was just a rabbit hole. It was some type of, I don't even want to say it was a cult. I don't even know what that was. Something was going on. All right. Um, in any event, they were, and this was many years ago, so this was my first introduction to how cell phone data actually worked, in the sense of how deleted content or deleted data is restored. And literally everything that these folks thought they deleted, I believe that was Verizon, I believe Verizon was the carrier, all of it was unearthed. All right. So if there is a mistrial this time around, and if there's another retrial, I would like to believe that the Commonwealth is going to go as far as um, um, what is this? Issuing a subpoena for Dr. Wolf's not contact, cell phone data. I would like to believe that, and there's definitely a way of retrieving those text messages. So, Real Thing says, I listened to your replay yesterday of the voir dire and how impressed you were with Brandon. I thoroughly I thoroughly know how you feel about Jackson and his conduct with. Yeah, I'm sorry. I'm really disappointed. Jackson has disappointed me. He will never regain my trust. I'm like, bitch. He's probably like, bitch, I don't even know who you are. But he's not. No. What's his name? Joe Takapina still gets another chance with me, but Alan Jackson, I cannot do it. No, he's not. I will never see him in the same light again.
Of Dr. Rensselaer, there is much more involved than simply logistics. But to get back to Dr. Wolf, he did not disclose to the court that he was communicating and having
And I need to stop cussing. I'm not cussing again.
conversations on Signal. How odd. An expert using Signal. Never used it before. Dr. Rensselaer said would not use Signal, never use Signal. But Signal, as we know, is an application that does not create a record of communications. Dr. Wolf maintained on his direct.
And I've said before in response to Brooklyn, I've said it over and over again. I don't text. Text is not my thing. I'm one of those people that use these encrypted applications, but in a few years, or maybe even now, that stuff might be retrievable. So you never know.
Everything he did was logistics. Even when we showed him the direct examinations with comments that asked for input from the defense,
right,
to questions in a way that would be advantageous to the defense and to thwart the Commonwealth, Dr. Wolf actually still continued to testify that that was simply procedure in logistics, never admitting the fact that there was, in fact, conversations or information exchanged about bettering the presentation for the defense. Inevitably, I asked him about the sequestration order and how evasive he was. You simply have to compare him to Dr. Rensselaer, who was quite candid. An hour or 45 minutes with Dr. Wolf, difficult getting a straight answer. Dr. Rensselaer told us more in 5 minutes than Dr. Wolf told us his entire examination.
Okay.
And what we unfortunately learned is that during the trial, when this court had a sequestration order, information was being passed to the experts about witness testimony, in this case, unknown to the Commonwealth, unknown to the court, information.
Yeah, so I would like to know, Real Thing, knowing what you know now about these defense witnesses, does that change your impression about him? And I suppose that question goes for everybody else. You know, I don't know, on Reddit they're talking about Jennifer McCabe. Oh, they're saying she had a glow up. Hold on, I'm distracted. But that's a question that I'm posing. I would like to know if these revelations about defense witnesses, if they sway you one way or the other.
Particular information, not general information, witness testimony, issues in the case. We have no idea who is deciding or identifying the issues and who the advantage is given to in describing those issues. But that is witnesses being prepped through an intermediary. So we know the Department of Justice, at least, is violating the order, helping the witnesses along, and then they testify unbeknownst to the Commonwealth that they have this information, but obviously is reflected in the testimony.
Okay.
In addition, I provided some clips to Your Honor for review.
Yes, do you want me to mark these as an exhibit?
I do.
Okay, so this was an exhibit from yesterday. Very important. I did have the opportunity to look at them.
I suggest that the relationship was not resigned to mere logistics. And so from that subterfuge, what we stand with today is that we know that the witnesses were well prepared. We know that there was not true independence. And what we know is that they are refusing to provide the necessary information to support their original opinions that they gave at the first trial. They cited that it was a protective order. Perhaps it is. That has nothing to do with the issue. By calling the ARCA witnesses as their witnesses, they then have the obligation to comply with Rule 14. Unlike the first trial, where the Commonwealth had no ability to do any testing, review, vet the reliability of the information, properly prepare for cross-examination, this trial, that should not occur. Just because it happened last trial and the Commonwealth was disadvantaged does not mean it should
There's a
happen this
new
trial. And that
sheriff
is
in town.
precisely why I began moving for discovery in this case early on. Inevitably, if these witnesses cannot provide information because it's under a protective order, it may not be the defendant's fault in inception, but it is their
I know. I think
problem.
what I need to do, I'm going to have to start ranking these attorneys. So when we get to the very end, I'm going to make a note for myself. When we get to the very end, when we get to the end of the year, we know who's on top, because so far I've been thoroughly impressed with, let me see, what is this, 2025? So far we've covered the Colin Griffith case. In that case, I think those might actually be the top two. Shout out to all public defenders. The Colin Griffith case, I'm comparing the prosecutors now. We had the Colin Griffith case, we have this Karen Reed trial, and then we have ASAP Rocky. I don't remember. I don't remember the older prosecutor's name, but I thought he was also pretty good. So far, I've actually been thoroughly impressed with the prosecutors that we've seen this year. Lally or Lally or whatever his name is, not so much, but he's not the lead in this case, so it really does not matter. And then as far as defense attorneys, I know I'm putting Alan Jackson at the very bottom. I'm gonna have to go with a public defender in that in the Colin Griffith case, because every once in a while, I mean, again, it's Florida, so they do have stand your ground, which may have assisted the defendant a little bit in that case. But those public defenders did a phenomenal job. They did some real work for that kid.
And difficulty because they chose to hire the ARCA witnesses. They could-
After that public defender, we're going to go with Alessi, just because, again, I'm biased, and I really do like Alessi out of this group of defense attorneys.
They've chosen any witnesses they want. Rule 14 is not obviated because they made a strategic decision to call the ARCA witnesses. So now going into this trial, even Dr. Rentschler admitted that
All
an
right.
expert should have time.
Let me drop the link. So we have Real Thing is coming up. She said she cannot type fast enough. So she's coming up, and I suppose Real Thing is actually the first co-counsel to come up here when I want a real lawyer. All right, real thing. I dropped the link.
In their opinion, a month or more to review the raw materials. It's not enough simply to have a report, as Attorney Lisi preached
Is it
during his
Alicia or
argument.
Alessi?
We should have the opportunity to go through the raw data, the history, the videos, determine whether there's any failed testing. We don't have that benefit. And so my position has changed, that those early opinions should not come in because we have no ability to fairly cross-examine. As for the new opinions, the report may not be done till May 7th. We are in the middle of trial.
Right.
Concedingly by the defense, or at least their witnesses, it takes a month to go through the discovery.
All right.
What I found out-
I'm so excited for real thing.
What's up? How you doing?
What's up, real thing?
It's been a long time.
I know, I'm so excited. I'm glad you're here. You sound good. I know you've had some stuff going on, but you sound
Yes.
good.
Well, thank you. Thank you for having me.
Absolutely. What's going on?
So I want to say first and foremost is I don't disagree with you. I don't. I want to make sure I'm not, I'm never like combative or want to debate. I don't even do that. I really honestly don't disagree.
Okay.
However, I do listen to several YouTubers, or really, they're all lawyers that are
Yeah.
covering, they watch this trial every day in real time and they give their commentary, education, all of that. And before I say anything else, I want to say I love that you are secure. You are secure in yourself and who you are as a lawyer as well. I
No,
really
thank you.
appreciate that because you are the only one that has that perspective of Brendan did such a good job yesterday, and I
Oh, he was
heard you
brilliant.
say it over and over how, well, if we can't see how brilliant it is, and if we have an issue with him and how he's basically exposing, right, the conduct between Arca and the defense, mainly Mr. Jackson's behavior and their communications and using signal and all of this. If we can't see what this really is, the truth of it, then we just must be, fanatical, Karen Reed, sycophants, right? I heard you. And I was like,
That's what I said.
wow. Okay, we have us regular lay people that are Karen Reed supporters. We feel like, no, I don't think she did this. It's just how we feel. Like
Right.
it ain't adding up with the facts.
Okay.
But then we have the lawyers, criminal defense lawyers, people with experience. And none of them were impressed with Brennan. They actually are laughing at him at his performance yesterday.
Okay.
I don't know. I know you are so busy and you might not see all they've made videos about it already.
Yeah.
Clowning him. And they just don't have that perspective of like, wow, this conduct that took place is a big problem. I can see it. I think it should be always be clean. I don't have to go to law school to know.
Right.
With the experts, even I'm forgetting the man's name. I think he's with ARCA too, how he ended up being invited to the lunch.
Rittenhouse or something along those
Yes.
lines. Yeah.
And even that, because then of course, what Brendan say, well, was the defendant's family there? Did you talk to them? See, of course he did. He's not, I know
Right.
he said he went and sat in a corner, but come on. Of
Yeah.
course he talked to people. So it's like, see, you got to keep it clean. Decline the lunch if
Right.
if your ride is not able to take him wherever to the airport or whatever, when he expected, he should have declined and said, you know what, that's okay, I'll get an Uber.
Mm-hmm.
Thank you, but have a nice day, and left just to keep it clean. So fast forward several months later, he's not on the stand having to answer these questions. Or even if he's asked about it, he can say, no,
Right.
I did not. I left and went home.
Yep.
So I was just thinking, to me, in my mind, I would love to just get your opinion on these other lawyers talking about Brennan's performance yesterday, but the other part of my brain is like, no, that would be like me like asking you to argue with the other lawyers on YouTube. And of course, I don't want to do that. I'm not trying to pit you against anyone, but I just think it's fascinating.
Okay, you can send me an email with the
Okay.
links. Okay,
Okay.
send me an email with the links, and I'll definitely come up here and talk about their perspectives without obviously naming, you know,
Mm-hmm.
who they are, right? But again, I understand the way the YouTube algorithm works. Okay, so if we, let me tell you, if you are, how do I put this without being overly cocky? But as far as the YouTube algorithm works, it works in a specific way. There's certain things that YouTube pushes, all right? I'm going to
Mm-hmm.
give an example of myself, and I'm going to talk about the channel itself, Sustained Overruled, not this one, okay? When I started Sustained Overruled, my focus was more so on Judge Mathis videos because I actually do enjoy watching Judgment. I mean, he's improper sometimes. He says stuff he shouldn't be saying, calling people crackheads and stuff. But overall, I do enjoy watching him. But as far as viewership and the subscriber count, it became very obvious to me that in order for me to do the numbers that I wanted to do, I would have to shift my focus to a different judge. Okay, so that's when I started doing um, the Judge Judy videos. Okay, so when I know right now it's like at 26,900 subscribers or something, but when I got to 27,000 subscribers on that channel, I got most of those subscribers within a space of like 2 months. Okay. So I pretty much blew up because the algorithm, the YouTube algorithm was pushing the Judge Judy videos. And that's what people were mostly interested in watching and viewing. Okay. And that's how I think I ended up, I deleted some of the videos now, but I did end up with over 9 million views or something along those lines. So the same thing is going to apply to, you know, anybody that's covering these Karen Reed YSL trials, and any other cases that are currently going on. In order for a channel to really blow up, you have to focus on, a lot of these viral cases, but you do have to have a specific perspective. All right. If we go, for example, because this Karen Reed trial is all over the place. I'm at work and I'm getting headlines from all types of news outlets, and this is on my work computer. I don't even know. I think we use Edge or something. I don't know, but on the landing page, it's usually, news articles and headlines and things along those lines. And a lot of the Karen Reed narrative is being pushed out. And if you do read the comments, most people are definitely in favor of Karen Reed. So I think that for somebody that's doing this type of coverage of a trial, in order to push numbers, get a lot of subscribers, get a lot of viewers, get people to give you a super chat, donate money to you, I think you do have to push a narrative that supports Karen Reed. As far as a defense attorney's perspective, though, if so, here's the difference. I've done both prosecution and defense, so that's why for the most part I do tend to be neutral because I can understand it from both sides. And it's not just from the Karen Reed or coverage of trials. Even when I worked as a public defender, there were times, I don't remember, there's an app we had, one of the offices I worked in, there was some type of app we had where that was a large office. There were a lot of attorneys in that office, so maybe that's why they had the app. But it was one of those encrypted apps that we used, and pretty much everybody in the office, not everybody, more people. I suppose the people, because I'm trying to think back. I suppose the people that were on this group chat were people that were actually in city and town courts. I don't know that they had the older attorneys on there, but in any event, every once in a while, I think about the discussions that were taking place on the app in terms of conversations, internal conversations between the public defenders. And I did not always agree with them because oftentimes there are times when public defenders think that a prosecutor should not be as hardlined or should not be advocating for the interests of the public. If a prosecutor asks for something, then suddenly people would be pouting because they I don't know, I guess they want people to capitulate to them. So there's certain things that I just do not agree with, but that's because I've done both prosecution and defense, and I tend to be more neutral, whereas somebody that has only been a prosecutor, or not a prosecutor, but a defense attorney, might see it as one way. And we also have to know the difference is that I don't currently represent criminal defendants. So if I think for any attorneys that are defense attorneys at the moment that would be covering the Karen Reed trial, I would like to believe that they are going to make statements, whether they believe them or not. They're going to make statements that are more in line with the duties of their jobs. Not everybody's going to be uh, not not more so. Oh, I mean, some people don't have self-awareness, but uh, I would like to believe if I am a criminal defendant and I ended up on a live and my attorney was siding with the prosecutor, I don't know that a defendant would be able to understand that, because people cannot always remove themselves from situations. That's a long response, but but that's my response. But do send me the link and I'll definitely take a look at the different views.
Okay. Thank
Yeah,
you.
certainly. And then I believe today is what, Tuesday? Yesterday was Monday. Yesterday there was a not a prosecutor. I believe that was a criminal defense attorney during the lunch break with Angelique Levy. And as far as the attorneys that they have, no, is today Wednesday? I'm confused.
Today is Tuesday.
Is today Tuesday?
Yes.
Today, I'm gonna have to take a look at my screenshots. But there was no, because I think yesterday was a lady called Safa or something out of New York. Like, I don't know if she's black or Hispanic. I don't remember. But again, there was an attorney that showed up there, or was that on Friday? There was an attorney that showed up on the lunch hour show, and
Hmm.
his reasoning was more in line with what I've been saying. And then because I listened to today's show, it was a little boring. Like the lunch break, um, the attorney that they had on there. The only thing that I remember him saying that is more in line with my beliefs, as far as these the theory about third party culprits, he reasons that it makes no sense for a house full of law enforcement officers to put a dead body on their personal lawn. That doesn't make sense. That's incredibly dumb. But as far as as far as a red herring for the defense, it works. But otherwise, it doesn't make sense. I don't know what else this and also this attorney from today's lunch hour. He also does not think that Jen McCabe searched, how long to die, whatever the term was.
Hmm.
And he is enough. To me, the science makes sense. What they're saying in terms of the explanation of having a bunch of open tabs, some of those things make sense. But if we're going back to, the comments and how people are reacting, at least the majority of people that are viewing this trial, a lot of people are in support of Karen Reed, and regardless of what the evidence show, I don't know that that changes their minds or positions. But to me, it really does not matter because I've said before, there's a difference between factual truth and substantive truth. Whether Karen Reed did, in fact, off her boyfriend or not, as far as criminal courts are concerned, it really does not matter. So that's me blabbing. What do you have to say, Real Thing?
It doesn't matter because it's only about what can be proven
Right,
beyond a
right,
reasonable doubt. Yeah.
right,
Okay.
right.
Just to add to what you were saying, as I always say, I know you don't need me to confirm
You're
anything you
funny.
say, but because I actually are watching, just to go back to the attorney YouTubers, I
Mhm.
see what you're saying far as algorithm. It's a certain dynamic, and across the board, all the major, we can say big YouTubers that are covering this trial, their viewers and they are supporters because they do send a lot of money, right? Through
Right,
the super chat and all of that. They're all Karen Reed supporters.
right.
So it wouldn't make sense for these attorneys if they really felt like Brendan was doing such a good job. It will kill their views
Right,
for one.
right.
And I see what you mean. I didn't think of it that way. So thank you for explaining all of that about the YouTube algorithm and how things are pushed on this app. That makes sense. And
Yeah,
lawyers y'all are very intelligent. You're very smart.
exactly. Nobody's
So
trying to mess up their money. So
exactly. I didn't think of that. So thank
I
you.
mean, if I monetized, I don't know, I'm not motivated by money, but if I had monetized this channel, my crazy ass would probably be out here screaming free Karen Reed. So, you know, so that's just, I mean, it does make sense from a business perspective, right? To push a specific narrative. Because listen, if, if, if if they know that their base consists of Karen Reed supporters, then people are not going to be showing up if they're talking about something else. If they're talking about how brilliant Brennan was. But if we are being fair, Brennan's cross examination was no different from Alan Jackson's cross examination. Was he hard? Of course he was. But he also got the answers that he wanted. And it's very clear based on that cross examination, it's very clear that there was definitely something going on between Alan Jackson and their so-called expert witnesses. That it's as clear as day, but people are going to overlook it. And again, if we do go back to this whole thing of uh, being biased, a lot of the folks that have been watching this um, will have a problem with the Alberts and all the other individuals that deleted their text messages, but they are prepared and willing to ignore the fact that Dr. Wolf did the same thing. So, you know, yeah, that's enough rambling from me, Real Thing. Do you have anything else to add?
No, I'll wait till the end.
Okay. All right. So let us get into this. But I'm glad you directed me to you know, what is this? The prosecution and the defense as well as the judge's decision, because I did not see this. I was just gonna talk about McCabe, even though her testimony, there was not much to her
It
testimony, but
wasn't much to it. This is the
yeah.
juicy part.
Right.
You're gonna love it.
Right. Okay, let's get into it.
By motion on the eve of trial that we would be unable to prepare or we would want a continuance in this case. I appreciate why this case wasn't continued,
Okay.
but I knew, given our scheduling, our experts will not be able to look at this material. Our expert is away until after the first week of May. He is going to be testifying shortly after. He will have no ability to digest this enormous amount of materials, vet whether it's accurate or not, conduct tests to combat it if he thinks it is inaccurate or unfair. And so the discovery violations, regardless of the state of mind, are upon the defendant. There is no exception that you used ARCA witnesses. There is no exception that you hired somebody that used to be under a federal
Who's
protective
this
order.
lady? Do
They
we
chose
know?
them, and I would suggest it seems strategically.
Do we know who this lady is over here? Is she just a spectator or no?
Just a spectator. She may be maybe with Karen Reed's family because her dad sits in front of her.
Right.
The,
Okay.
the her
Okay.
her parents.
Yeah. All right. And I have a question. This is random, but I've been thinking about this Real Thing. Maybe you have an answer, but sometime this week or late last week, I was trying to figure out what happened to Surviving YSL. What the jurors just disappeared. The channel did not really do anything anymore.
Yeah, I didn't hear much, but I remember when it, the verdict was read, I
Yeah.
remember hearing wise people saying they better pump out as many videos as they can as
Right.
quickly as possible because people will move on. I think you said
Right.
that too.
Right.
So
Right.
I mean, we're on to the next trial.
Right.
We've moved on.
I suppose over consumerism, right? Okay.
Yeah, ASAP Rocky's trial happened, so
Right.
there's nobody cared about YSL no more.
Yeah. Okay. All right. But I was just curious. I wondered if you knew what was going on over there. But okay. Thank you.
We noticed we'd have new experts in October. The defense, from past experience and probably other experience, but we know from this case, knows the process. They would have to file a TUI letter and wait for a response. And yet they waited until February to seek permission, which then extended their permission past February into March. And then they didn't even start the review until late March. And so it's fundamentally unfair. We should not be placed in a position of cross-examining experts without the fair ability, as any participant, defendant, Commonwealth, any participant would have in a case, to consider and then to rebut. And so for that reason, I ask you to exclude both the new opinions and new testing, and also to exclude the earlier opinions that we will never, at this point, receive the proper discovery with to prepare.
All right. All right. Let's
thank
see.
you. Mr.
What does the
Alessi, I
fence
only
say?
have one question for you.
Sheesh.
So would
Okay.
you
Hold
stand,
on.
please?
Hold on. Hold on. Hold on. She's coming out hot. All right. Let's go back. She only has one question. Okay.
Mr. Alessi, I only have one question for you. So would you stand, please? You're
Hold
arguing
on.
this.
I just
Mr.
need to go
Alessi, I
back.
only have one.
I have to look at everybody's reaction. I just need to digest all of this.
All right, thank you.
Okay.
Mr. Alessi, I only have one question for you.
Going on.
So would you
Okay.
stand, please? You're arguing this, right? This was your motion. So my question is, how do I reconcile the fact that 100 text messages were deleted by counsel? And we heard yesterday counsel's preferred method of dealing with Dr. Wolf was via Signal. How do we reconcile that with the Massachusetts Rules of Professional Conduct 1.15? I don't see how you reconcile that, where all cars.
Let's just talk about professional responsibility a little bit, okay? Because we've seen this come up. Most okay, we've seen it come up in Fulton County. Definitely when it comes to Fannie Willis, and it also came up when we talked a little bit about it in relation to, I believe it was Kayla Bumpus. All right. So let's talk about professional responsibility, and I'm just going to talk something that's a bit more personal. All right. So there is a rule against inadvertent disclosure. All right. Let's say, for example, usually these are like scenarios that professors might come up with during midterms. Maybe it might even be a bar exam question. Not something you'd expect to see in real life. All right. But one of my colleague once received information from opposing side that would have helped our client, but obviously it was sent inadvertently. The other side did not mean to send it to us. And this attorney that had been practicing for not as long as I've been alive, because I'm not I'm not that young, but she's been practicing for a significant amount of time. She was hopping up, jumping up and down about, this thing that just landed in their lap. And she was excited to use it. I'm like, you better tell those people that you received this information, because it's inadvertent disclosure, and you potentially could be disciplined for using information you have no business, using, that was not meant for you. But there are attorneys cannot just do whatever it is that they want to do. And we, again, last night we talked a little bit about Alan Jackson and what this could potentially mean in the event of either a conviction or if somebody decides to put a complaint. But let's move on, because I don't want to drag this out. I don't want to drag this out 'cause I can
correspondence
talk.
related
I
to
can
the
talk
matter,
forever.
whether in physical or electronic form, must be saved for 10 years minimum.
And I've said this before, even as we're having this discussion yesterday. You don't destroy, you do not destroy, you cannot destroy evidence during the pendency of a case. It doesn't make sense.
How do you reconcile that? How do I reconcile that?
I'm gonna, should I go to the podium?
Right there, and I expect a short answer.
Hold
short
on.
answer-
I don't know. This is okay.
She says, "Stay right there," and I
Right.
expect a short answer.
Right.
Get straight to it.
This is
Dang.
fiery. This is
Dang.
it's fiery, but they brought this upon themselves. But let's see how it plays out. She's not playing.
Years minimum. How do you reconcile that? How do I reconcile that?
I'm gonna, should I go to the podium?
Right there, and I expect a short answer.
Respond.
The short answer, Your Honor, is the rule that you're citing has absolutely no applicability to this proceeding for this. Can I finish my answer, Your Honor?
Right ahead.
Has no applicability. That rule is.
I don't know. Look at everybody over here. They're just. This is just.
They were nervous. I was looking at all their faces too. They were
Yeah.
like, "Oh man, don't tell me she's about to say no." They're nervous.
This is just. But they created an issue that should not have existed. This is just. It's incredible.
Finish my answer, Your Honor.
Right ahead.
Has no applicability. That rule is intended to be between an attorney and the client. The court has no jurisdiction to enforce that rule.
I agree. That's a different body, but I'm asking you how I reconcile that when I'm trying to figure this out. Mr. Lessie, you know what? You're going to win this, so why don't you just let me make my ruling, okay? So I understand there have been repeated violations of the reciprocal discovery orders and my orders, repeated and deliberate. But, and Mr. Brennan, I understand completely the Commonwealth's argument, completely the ambush that has been set upon here. However, a defendant's right to a fair trial is paramount to everything. So
You said
I'm
that
going to
yesterday.
allow the ACA.
Yeah. I mean, some people can get on the internet and pretend to be attorneys, but I'm not a pretend attorney. Okay, I am not a pretend
real attorney.
I'm a real lawyer. All right. Yeah, this makes sense. I could not see her ruling against Karen Reed because that would have presented real problems.
Witnesses to testify. I am going to allow what I expect to be a very robust.
I don't know. This is painful. This is painful for Bev Canoni. So, yeah.
Cross-examination. And I'm going to allow them to testify to everything that they said up until yesterday. So you'll get the report May 7th. And I know that's late. And if you need anything as a result of that being late, I'll hear you on whatever motion you have. But that's where we stand. And I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct and no more nonsense. Let's just try this case. All right, that's it. I'll see you tomorrow.
I don't know. A girl said, cut the crap out.
I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct and no more nonsense. Let's just try this case. All right, that's it. I'll see you tomorrow.
All right. Okay. Yeah, that's how I expected it to go. It makes sense. But that's because, again, Karen Reed is a criminal defendant. In a civil trial, it probably would have panned out differently. But for a criminal case, she certainly made the right ruling. But the prosecution's not going to be happy about that. But obviously, Karen Reed's satisfied with that. I am baffled. I'm baffled by Jackson's conduct. It makes no sense.
I love what you said yesterday. You said, as if the gift of Proctor wasn't enough.
Right.
You already have everything.
Right. That's all you need. That is all you need, because
But yeah.
now they've pretty much just weakened their experts. So I guess having an expert is still better than having no expert, but the credibility of Dr. Wolf is going to be shot on cross examination, because we're going to see a repeat, and he's definitely going to get grilled. There's no question about that. So, yeah, I don't know why they complicate. I guess again, some people do enjoy puzzles. They do enjoy complex cases. So this is just it made no sense, but she made the right decision.
Well, did you see Alessi? Most people feel like he destroyed their expert today, Mr. Ian, the
Uh,
forensic expert.
was that the first witness? I think there's a witness with like an accent. I know I have an accent too, but is that?
Yes, he does have an
Um,
accent. The first one.
yeah. Here's the thing. I like Alessi's approach, and
Mm-hmm.
that's because he is not as aggressive as an Alan Jackson.
Yeah.
But I do not know that he has destroyed the prosecution's witness. I don't see that. Maybe I'll have to rewatch it, but I do not. I don't think that he did. I don't think
Okay.
he did.
Well, I
Yeah.
guess the main point that he was driving today is that because of this case, they they have reprogrammed their software, and now the how's long to die in code, it won't show up as that 22740 timestamp. Isn't
Oh,
it doesn't exist anymore with the new written program.
oh, you're referring to the portion where they're saying, or at least during cross examination, it was brought out that they deleted information, something along those lines.
No, no, it's based on the software. So basically, what I and you can rewind and
Yeah.
you know look into it. And if I was a juror, that we everybody was saying the jury is lost, and that's going to maybe help the defense, because uh obviously Brennan wants the jury to be convinced that Jen McCabe definitely did not Google that at
Mhm.
2:27 a.m. He this witness was supposed to, solidify that, verify that.
Right.
And with Alessi's cross, it got confusing. But what I interpret, what came out of it, and I want to hear your interpretation,
Yeah.
was that he's saying the software, if Jim McKay's was to bring her phone in, the same exact phone she had on that day on January 29th, 2022, she was to bring that phone in right now, and they extracted all the data and nothing was deleted. That ain't even the issue. Let's say she didn't delete nothing. They extracted it right now, today. How's long to die in code would not show up at 2:27 a.m. because whatever they did to their software will not extract that from the phone, because supposedly it never happened, right? It was just an open tab that she had open at 2:27. So they have rewritten their software to make sure it doesn't show up as a Google search at that time. It shows up as nothing other than a tab being opened. They rewritten the program.
Right. So when during the cross, I guess during that second, the first witness for the day, I was, I'd get up and sit down and go to a copier and do all types of things. But
Mhm.
remember, um, what I do remember the testimony being prior to the lunch break. I think this was prior to the lunch break. I remember the witness testifying, or at least Alessi asking him about whether these Celebri people deleted um, text messages or something along those lines. I guess text messages is not the right word, but what I remember the witness to testify to was that I'm going to say they rebooted their system, and he was trying to further explain that, and Alessi would not allow him to do that. Is that the same thing, or was that?
Yeah.
from
They,
heart.
yeah. We're not the developers,
Yeah,
right? So we don't know the right word. So we're saying the
right,
same thing. Rebooted it, rewritten it, did
right.
something else to it, to the fact that they're saying, okay, he was saying it made it look like in the previous trial, which they're not, not supposed to say there was a previous trial. In the
Right.
previous proceeding,
They've been saying it the whole time.
right? The jury knows now.
Right.
They they felt like the jury, was basically presented evidence that that Google search definitely took place at 2:27 a.m. The way that what's the name of the company again?
Celebrate or something.
Celebrate. The way
Yeah.
Celebrate data, their report came out and it said 227 timestamp. It showed, it was a Google search at that time. So basically, them knowing their software, they're trying to say like, no, we knew that that's not accurate. It looks like it was a Google search, but we know that that was not accurate. So
Right.
we fixed it. It's like, oh, we recognize, oh, that's an issue. It's
Yeah.
making it's giving the wrong evidence, the wrong information to the jury,
Hmm.
and let's correct it on the back end.
Yeah.
Let's rewrite, reboot, and make sure it wouldn't show that. So now that it's being retried, a new trial, they can now have the accurate information. But of course, the defense is not going to go with that. They're not going to
Right.
stipulate that. Oh no.
Yeah. Right. No, but what I took away from the first trial, I thought, I mean, Lally or whatever his name is, I still don't know if is it an A or is it a U? I don't quite
I
remember.
believe it's a A. I call him
An A?
Lally.
Oh,
Lally.
Lolly? Okay, I don't know. That's what we're gonna go with then. So the first trial, even though Lolly was not that efficient, I think what I took away from that first trial was that that was not the search did not occur at that time. That was just an open tab. That's what I took away from that first trial.
Yes,
Eh,
me too. Me too. I
So
wasn't convinced with his expert, but yeah.
right. So as far as if we go back to what I said yesterday, sometimes it helps to not touch things, like leave it alone. So again, obviously with the Celebrite people, they probably saw or a need for them to correct themselves and correct their software. But if I was the prosecutor on this case, I probably would have just left it alone. Leave it alone because you do actually have an explanation for why it shows up that way. So I don't know.
You know what? That makes sense. You know what? Brennan is probably saying that now.
Yeah.
Now that he's at home thinking about today, the way the cross examination panned out, it
Yeah.
wasn't even worth it.
Right.
It was so bad. Like, because the expert, he has his own application he created,
Right.
and he's done. Did you hear him about his own experiments he did, his own testing by putting his own cell phone in his freezer?
I heard that.
Soon as I heard him say that, I was like, oh no.
I
I
did
know.
hear that.
And it's like, I know Brennan was cringing the whole time. Like,
Yeah.
no,
Yeah.
no, 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 don't say that.
Yeah. No, I heard that. I heard that. But my focus was not really on him because I knew that, or I was prepared for Jen McCabe. And I don't know why I thought we were going to get to cross examination. I should have known better. So I was more focused on Jen, but I did hear him talk about his experiment and, a freezer and all types of things. But yeah, I think the prosecution should have left. They should have left the integrity of that. They should have left the integrity of the software and the report alone. Like, you know this now, so correct it for your future program, whatever. But leave things as they are because you do have an explanation for why it shows up the way that it does. So I don't know, but again, Brandon said the science, the facts, and something else. I forgot what the third thing was. So I suppose, what was that?
No, I was just thinking, it probably would have been better, but I can see why he wants to try to get rid of it. They really want to get rid of it completely, because even Alessi said, probably I think on Recross, he
Yeah.
says, that it's very crucial about this Google search when it
Right.
really took place. Did it take place at 2:27 or 6:23 a.m.? This case, is like really a cornerstone piece of evidence in this case. If it could be proven for sure definitively that she did Google that at 2:27 a.m., it really will have a huge impact on the verdict.
Right.
So I see why Brennan is going, like, let's go for it. Let's show that we can get rid of it altogether. It doesn't even show up. And it's not that they were saying they Celebrite has deleted it. I know you were just saying that they're saying no, it doesn't show up because it wasn't a real search at that time. That's not what that original report meant. It showed up as a timestamp 2:27 Google search, but it really
Right.
wasn't that. So we've corrected it, and now if you ran it, it wouldn't even show up at all. And that's
Right.
what Brandon wanted. Like, see, it doesn't exist. It didn't happen at 2:27 a.m.
I can understand that, but as far as cross-examination, I think depending on who the jurors are, that does have the potential of completely undermining the witness's testimony. Um, and that's going to be a problem. That's a huge thorn for Brennan, because Brennan does not want to Brennan wants the jurors to focus on the impartial witnesses. He wants them to focus on the experts and pretty much folks that have no interest in this trial. Because again, we know that law enforcement is going to be problematic. We know that Jen McCabe might be problematic to some extent. Carrie Roberts was definitely problematic as far as her testimony before the grand jury. So if again, as far as where the prosecution or the prosecutor wants the jurors' focus to be, you kind of do not want the jurors to, have to overly scrutinize what a neutral witness said, because otherwise, then it kind of seems like they also have a stake in the trial when they actually don't. So, yeah, I personally would have left it alone. I'd have left it alone. Sometimes it does help to not touch anything at all, like leave it alone. So, yeah. So I suppose let's quickly get. Do you have a timestamp for that cross?
You said it was before lunch. I thought it was after lunch, but
Really, I don't know, because I was not really taking down. It helps when they have a clock over here. When I don't have a clock, I don't really have a reference point. But maybe let's go back to Brennan's. I think that's Alessi. Let's find Brennan's redirect. I did not watch the end of that redirect though. I don't know that he got much accomplished, but let's see if we can
no,
find a point. Oh, you don't think so either?
I don't. But I mean, you're the attorney. I
Yeah, no,
know
I
that.
do not. As much as I do like Brennan, I do not think that he was able to rehabilitate this witness.
No,
Yeah, let's see.
everybody's brain was fried by the time Alessi was,
Right,
finally done with his cross. Anyway, like, we're just like, huh?
right. Yeah, let's see. I'm just
It was
trying to.
good though, especially with the just being able to use his own report and
Right.
everything, like the 84 feet, and it
Yeah.
it was measured from the flagpole to the front door, 74 feet. Oh, and
Right.
then
Right. I
additional
remember
steps
that.
into the house. Okay, the jury can do math.
Right. I remember that.
The cell phone temperature, the battery's temperature is not, it didn't decrease as much as his cell phone battery did in his own freezer.
Right. Yeah. Yeah. Let's see.
So the question
And
is,
then today, did we see any Karen Reed clips or no?
No clips
Okay.
from Brendan
All right.
today.
And yesterday, because I was trying to find clips, but I don't remember seeing any clips from yesterday.
I don't remember seeing any yesterday.
Okay.
Mm-mm.
Okay.
Is it?
Yes.
But I was thinking about that today during, the Law and Crime lunch show, whatever it's called. And they had Karen Reed still out there in front of the cameras talking to the media. That's just the strangest thing. Not even strange. That is just plain stupid. That is what's up, Zeta? Okay, so yeah, to me that was just the dumbest. It's just incredibly stupid because while the prosecutors, I guess let's actually do that. Let's go to close the door, mama. Let's go to the lunch break. Let's do that because we're not going to succeed trying to find that timestamp. But I think on the lunch break, I should be able to spot when Karen Reed is interviewed.
I think she just been feeling so compelled to, just like she said, to testify in her own way and tell her own story. I mean, obviously, certain things my my grandma used to say, well, it seemed like common sense ain't common, right? We've heard that.
Right,
I would say, okay, journal, talk to your family, and
right,
wait,
right,
pray and hope for an acquittal. And then after you're found not guilty, go and do all
right,
the documentaries you want to do in the world.
right. Like, do
Talk
you
it
know
all up.
how many people have been acquitted to later confess? Like, listen,
Right.
I just did not. I am just. Oh, here we go. Here we go. I'm just puzzled because while Brennan is bringing all these clips in, why I think there was something that caught my attention. But let's quickly play it. Let's play it.
It could
Let's hear.
strategize client I've ever had.
Very, very involved.
Okay.
Could Karen's deep involvements, at times appearing more like co-counsel than a defendant, shape the jury's perception of her guilt or innocence consciously or
I did not hear this
subconsciously? That's a
question.
pretty good question, because she is very, very involved. I mean, this
Right.
is an intelligent woman who was a college professor. So, Austin, what do you think?
Yeah, she is extremely involved, much more so than a lot of my clients, possibly more so than any client I've ever had. And you see it in that documentary series as well. Behind the scenes, you get a look at her in these meetings with attorneys, strategizing with them, which oftentimes doesn't happen with a defendant in the room. And then in court, you see her attorneys going to her and her whispering questions that she wants them to ask. Again, you don't see that very often in a
Okay, I kind of okay. He says he does not see it. The one thing I've always known about clients, they're always asking random. They always, at least shout out to all public defenders, okay? But I've had a lot of clients that like to talk during trial, that are passing you little notes, that are asking questions. So it does, at least in some counties that I've been in, I've had clients that want you to ask specific questions. Not that I ask the questions, because sometimes clients want you to ask questions that actually incriminate them. So I don't know, but it's neither here nor
courtroom.
there.
So I guess to get to the question, how does that impact what the jury's seeing and what they're thinking?
Okay, what's going on?
Somebody that involved in their own defense, it could cut either way. It could be, wow, this person really has it together. They're on top of things and they're participating in their defense like I would expect them to.
Right.
Or it could be she's orchestrating something and it's something shady's going on here. You just never know what lens the jury's going to look at it through.
Yeah, you really don't. And I wonder what they think of her going up for the sidebars, too, and they may think nothing. I mean, if they're
Right,
first time
right.
jurors, they may think this is totally normal, no big deal.
Right. But to your point, it is extremely
I'm just
abnormal.
waiting for the
I
Karen
mean,
Reed,
again,
clip.
Yeah, it's not something you
there are
see.
things that you expect a defendant to participate in and things that you don't.
Right.
That's one that you don't really see a defendant participating in.
Yeah, you don't see that a whole lot. So, one thing that's come up a lot, and we were just talking about the docuseries in this case, Austin, is Karen Reed's statements. And there are a whole lot of them.
Right.
And they've come in this trial, and we've seen a lot of them that just, they don't look like they're helping her out a lot. The Commonwealth is presenting them. And so she was asked about that before opening statements began, several days before opening statements. So let's take a look at what Karen Reed said, and then we'll talk about it.
Okay.
Karen, how do you feel about the jury being seated? Stay.
Please.
I mean, that is just incredibly stupid. You're making statements about your statements being used against you. It's just, I don't know.
We're loaded for bear, ready to get the show on the road, and we're happy with the whole process today.
Karen, last 2 weeks. How do you feel about Hank Brennan planning to use your interviews in his opening statement?
Come at me.
That's for your dad.
Like your dad.
I may have seen it. I would not have said anything that I wouldn't say again.
Okay, this is what I had a problem with. Okay. Her basically saying that she would not have said anything that she would not have said again. Brennan could pretty much chop this up and have this as one of his clips towards the very end of his direct testimony, because it's problematic. What she's basically saying is that whatever it is that she said in the interviews is the truth, even if it's proved to be otherwise. So I have a problem with attorneys and criminal defendants that love being in front of the camera. I just
I
that's really
agree.
problematic.
I agree. I thought about this too. I was thinking, I was like, why? Why would she even do even any of it? The
Right.
documentaries, all the talking. And I came to a couple of conclusions, my own just opinion.
Yeah.
Number one, you can tell in the way that they talk, her and Mr. Alan Jackson, they're very confident, perhaps overconfident. They're overly confident in what they have, created in her defense. They feel like, no, there's no way a jury will find her guilty. And even the juror coming to tell them that she was acquitted on count 1 and count 3 even like has boosted that. They're like, yeah, that's the main, those are the main charges, and she was acquitted and she could be acquitted again. We're going to do it even better. And I'm sure they have. We can tell they are presenting even his cross-examinations last week. I know you feel some kind of way about him, but as an attorney, I know you like, yeah, he did great.
No, he did great.
He did great. They're ready and they're so prepared to do what they can to show all the holes in the prosecution's case. And there's many holes, we know that. So I feel that they may be overly confident. And it's a criminal trial. I don't have to go to law school to know she can't be too confident. She doesn't know what's going to happen. This time, they do have a special prosecutor who is more efficient and more effective. So she can't just think, I could say whatever because I know this trial is going to go the way that I think it's going to go. And the other thing is, if it went the way, like this whole incident with the Alberts and all of this, I know she feels betrayed even by John O'Keefe's family from her perspective. So she enjoys the support and the attention. And I can understand that on a human level. John is gone and he's gone in a very traumatic way. She was definitely traumatized and she's on trial. She's being accused of being the reason why he's gone. So having to fight for her life, being betrayed, it's a lot. So she sucks in. It's like she's soaking up all the love, all the support, all the attention. Yeah, I want to show you I'm strong. Look what they're trying to do to me, but I'm strong. Bring it. Come on, come at me.
Right. I was about to say that. I was literally about to say that. Okay. Yeah. So that is an interesting perspective, right? In terms of the support and the attention that she's obviously gained through her press runs. my my reasoning, I think primarily the reason why they gave all these interviews, just from an attorney perspective, is to really pollute the jury. I think that's the main reason they did that. I think that um, the goal was to reach out to as many potential jurors as possible, so that in the event that, not in the event, because we already knew this was going to trial, but I think their end goal was to pollute the jury, to try this case um, in the eye of the public, and in the hopes of either an acquittal or a hung jury. Because again, I think they've accomplished, they may have accomplished that mission. And the reason why I think so is because, for one, um, a lot of potential jurors during voir dire, a lot of them had indicated it was about, if I remember those numbers correctly, it was about close to 80%. And I'm just thinking of specific days when they had the data. Out of 100, you would have about 80, 85 individuals that had heard about the Karen Reed trial. And what I found troubling is that even though such a large number of individuals had indicated that they had heard of the case, very few people disclosed that they had formed an opinion. Listen, even when I come up here, right? It was only, and again, I like to talk about cases that we've watched together, so we have a point of reference. uh, Most attorneys that you're going to see, and I'm not talking about other attorneys that cover this trial, more so the attorneys, focus on the attorneys that they bring on during the lunch break. And I want to say it was on Friday when Jesse had some attorney up there. I don't remember his name, but I did take screenshots because I was supposed to crank out a video, but I was rock climbing, so I I did not have time to do that. But there was an attorney, and a question that most lay people often want to know is whether an attorney believes that a criminal defendant is guilty or innocent. Okay. So Jesse was prepared to answer that question, but the guest attorney declined to answer. And with the cases that I cover, if you go back and listen, you would have picked up on that pattern as well, that I never come up here and talk about whether I think a criminal defendant is guilty or innocent. But that's going to be different from the other people that, or at least the other attorneys that cater more to Karen Reed's base. They're going to come up here or come up on YouTube and say that they think she's innocent because that's a safe answer. All right. But ordinarily, the reason why most attorneys, like usually people that tend to be impartial, would not want to talk about the guilt or innocence of a criminal defendant is because, again, we're going back to, if you understand who has to prove the burden, in this case, always the prosecutor, and that the defense really has, they really do not have to do anything. But again, I still find it troubling. Here's the thing. Everybody, everybody that has followed Karen Reed, even potential jurors that may have, heard about this case, everybody has formed an opinion. There's no question about that. So, oh, Real Things device is connected. Something happened to her connection. Hopefully she comes back. But um, everybody has formed an opinion. There's certain things that make sense, certain things that don't make sense. Again, based on the lens through which you're viewing this. So going back again to the jury, and or potential jurors, no, I mean it's an impaneled jury right now. So going back to the discussion of the interviews and the press runs that the defense was making in this case, um I strongly believe that the reason that they engaged in the press run is more so to pollute the jury. And again, this is confirmation bias because another attorney, again, I think he was from Friday, he's a guest attorney on the Law and Crime lunch show. He came to the same conclusion that the reason why they did that is to reach out as to many potential jurors. And again, my concern it was with the fact that a lot of potential jurors um, pretty much said that they had they were aware of this case, have heard of the case, but very few of them were willing to disclose that they had formed an opinion. And I find that hard to believe. But I think that plays more so into the defense lap because they're hoping that somebody out there that is favorable to the defense and Karen Reed, could potentially be a holdout. So, yeah, that's my opinion on that. So, real thing, any real thing disappeared again. Real thing disappeared again. Okay, so real thing, I'm gonna play this just a little bit. Hopefully you come back and then we get your okay, she's back, so we can get your closing. All right, real thing, any closing? It's been a while since I did a closing argument.
No closing argument. I actually had a question for you. You don't have to
Yeah.
answer it today.
Okay.
So, and I know better than to ask you. Thank you for saying that. We know you'll never say if a defendant is innocent or guilty in your opinion. But here's my question. So we know the prosecution has a lot of bad facts that they have to try to deal with.
Right.
On the defense side, outside of these documentaries she has done,
right,
which if she hadn't done them, there would be nothing Brennan could use, but nevertheless, it is what it is. Outside of that, far as real evidence, in your opinion, in your professional opinion, does Karen Reed have any bad facts, any real incriminating evidence against her in this case?
Okay, so let's do this real thing. Put that in the email with a link of the channels that you're going to recommend. And let us revisit that question at the close of the prosecution's case.
Sounds good.
Yeah, let's revisit because again, the defense is not really going to matter that much because they don't have to prove anything. They don't have to do. So let's revisit that. And I have a tab on my phone. I have a tab for video ideas and questions and things I need answered. I still have D. Williams on there that we're supposed to cover in terms of how that her cases, in the YSL trial. I just don't get to some of these things, but definitely write that out, and I'm gonna put it somewhere on my wall. And then we revisit that once the prosecution comes to a close. Because again, with Brennan, we don't know what he's gonna do. We can assume, right? But we don't exactly know what he is going to bring out. So, but if we are looking at the witnesses that have testified so far, and primarily focused on the people that were there that night, if we have to look at what's her name, Carrie Roberts. I was going to talk about Jen McCabe, but she's not done testifying, so that's probably not fair to her. Let's see how cross-examination goes for Jennifer McCabe, because the biggest problem with Carrie Roberts' testimony, again, is that lie, that false testimony to the jury. That is problematic because, again, it depends on how individual jurors decide to split that. The one, they could decide that, oh, she lied before the grand jury, so she potentially lied about everything else, and that is bad for the prosecution. Or some jurors might argue that, well, she was consistent about everything else, with the exception of, this so-called conversation between Karen Reed and Jen McCabe about, the text message or the search or whatever it was. So it just depends on how they
which is connected. It's all connected to this supposed Google search at 227.
Yeah.
That's really Carrie Roberts' testimony. That's the crux of it.
Right.
Oh, she didn't herself hear with her own ears.
Yeah, that she was
Karen
sleeping.
asked Jen
Right,
to Google. But the fact that, oh yeah, Jen McCabe told her later,
right.
Karen told her. Yeah.
Yeah, but as far as splitting Carrie Roberts' testimony, though, there's also the testimony about the crack or the missing piece in the tail light, right? So it
Hmm.
depends on whether the jurors decide to split that testimony or not. In terms of, I mean, you have this whole thing about whether Karen Reed showed them the broken tail light as they were entering or as they were leaving. We know that the surveillance footage or the ring camera footage shows them entering, and there's no discussion or congregation around that tail light, whereas the surveillance as they were leaving apparently is missing. And according to John O'Keefe's mom, Karen Reed and the father and the brother showed up, went upstairs, and then they just left within 15 minutes. So I think actually now talking about bad facts, that's actually a very puzzling one to me.
Hmm.
The fact that your boyfriend of 2 years is deceased, and when you stop at this home, you don't, I don't know, hang out with these people for a little bit. I don't know, make coffee, drink something. You just go upstairs, take your stuff, and leave. And I do not know. I have to think back, but I don't think that she was a suspect at that point. So I don't know. But one could also argue that she was going through a mental health crisis and the focus was on herself. So it just, there are a number of ways of arguing
Yeah. I,
things.
I mean, we don't know, but it does. I believe her when she says, basically she was reading the room when she got back to John's house. She could
Yeah.
feel the energy of them. That's what you're talking about, right?
Right,
The
right, right.
Okay. Yeah, she could feel it sounded like they weren't welcoming. They weren't like, you know, coming together to like hug or be like, wow, like, dang, John is gone. Or it was it looked like they was looking at her with the side eye when she came in. Like, well, what are you here for? What do you want? Even his mom said, even at the hospital, she said to the nurse, what is she
Right.
doing here? What do you mean?
I
She
think
said,
from that context, the way again, they probably should have fleshed that out in
yes.
order to know exactly where these people are located, right? Because I'm trying to figure out, is there a partition? Is she on a different side of the hospital? Exactly what is going on? Is she being held? Because I don't know, but again, we're just speculating as we do over here. But I do have questions about that, and maybe they do flesh it out. We'll see if later testimony is going to flesh that out for us or not.
Yes,
But I
but you
do,
could,
I
but
think about it.
at this time though, you can see, just going back to what you said about her coming back to his house and she didn't really say nothing to them. I think a juror at this time can also remember that, his mom, understandably so, the way she testified was like, it like she wasn't really feeling, she wasn't, trying to bond or really understand Karen or be sympathetic or empathetic with her and what she had just went through. Just the simple fact of asking, even though it could be taken many different ways, what is
Mhm.
she doing here at the hospital? Like, what?
Yeah, but I think the main purpose of Brennan calling the mother, the main
Yes.
purpose was really to testify to the footage. That is what the jury is supposed to draw here. They're supposed to draw an inference that when Karen Reed went upstairs, she and her folks removed, um, I don't know, a disc or something, or an SD drive, something along those lines. I think that was the real purpose of calling her to testify. That was the real purpose of that testimony.
And everyone was saying it was to humanize John and to pull sympathy and empathy for him from the jury, to pull on their heartstrings. It's very interesting. It will be fleshed out
Yeah,
because
and go ahead.
Jackson
I'm
is going
sorry.
to bring to the jury's attention that only Proctor had access to that ring footage and all of that. But there's no way Karen, and this is my opinion, could be in the state of mind that morning to think, oh, let me get to the ring footage because I had pointed out my tail light. Nah.
I don't know, but I know that when Peggy O'Keefe testified, I did say that Brennan did a good job of bringing or directing the jurors' attention to who John O'Keefe was as a person beyond just a victim, a faceless victim in this case, and that's why I'm going to paraphrase now. I believe Brennan during direct said. Tell us something else about him just being besides him just being a police officer. So that's when the mom started talking about how he had taken on his niece and nephew. But to me, what I took away from the mother's testimony, what her real purpose
Wow.
was to testify about Karen Reed going upstairs. Um, and I think that's the inference that they're supposed to draw. Because again, if we go back to the YSL trial, when it came to Taisha, the prettiest girl that whatever his name is ever dated,
Yes.
to me, when she testified, it was very clear, even though she tried to be evasive and to a lay individual, it did not appear that she was helping the prosecution. To me, it was very clear that the purpose they brought her there or put on the stand was to really put the gun in SB's hand. So that's what I took away. That was my main
Yeah.
takeaway. So maybe things do change, and we'll see how um, things progress. But the other purpose was really to lay the foundation for those
Wow.
Karen Reed videos to come in, where she was mocking the mother and basically, saying things that contradicted what Peggy said. So,
Wow. Thank you for saying that because I actually did not get that from her testimony. I wouldn't have drawn that inference. And I do remember Peggy saying, which I thought was like, wow, why did she say that? Do you remember? She says, like, she's saying that, like, in hindsight, she said,
right.
I don't know why I let them
Yeah,
go up there.
she
I
did
don't
say
know
that.
why I would let them do that. I was like, whoa,
Yeah.
well, you think she stole something?
But
Why would you
that's what I
say
took
that?
away. That's what I took. And again, this is connected to Kerry Roberts' testimony because during redirect, Brennan asked him, not him because it's a woman. Brennan asked her about whether she had ever seen surveillance footage of, their interactions as they were leaving the property, and he kind of brought in that the surveillance is missing or it's lost or something along those lines. So that's just really connecting the witnesses to each other.
We'll talk about it again because there is footage of her once she hit the car, when she hit John's car, her pulling out. Why she didn't delete that too? Just delete all of
I
it.
don't know. We'll have to see. I don't have a ring camera. I don't
I
have a
do.
ring camera,
I
so
have.
I don't exactly know how the data is stored and how things work. But I suppose we'll find out. Maybe we don't even find out because a lot of this is really circumstantial evidence. So, you know.
Well,
So
shout out to everybody that listened to us tonight.
I
Allie
know.
and
Shout out
Brooklyn
to
and
everybody.
Benji,
Yep. Shout out to
co-counsels.
everybody. Shout out to all co-counsels, Ali, Benji, Brooklyn, and shout out to the replay crew. So I don't know. Do you have any closing remarks? Anything you'd like to say before we get off here?
I think Jen McCabe has had media training.
Okay.
She has attended trial advocacy classes. She has had trial preparation
Yeah.
classes. She has had a full makeover and she is ready for
Yeah.
Mr. Alan Jackson, baby.
Oh, you think so?
Oh yeah, she ready. She said, "Bring it on." It ain't gonna be like last time. She got something for him this time.
Right.
She's gonna be ready for all the answers. You see, she was so perfect.
Right.
I watch hearings all the time.
Yeah.
Most people do not know that they have to spell out their name. Like
Right.
usually they
Right.
have to tell them again. Can you state your name and spell? She was ready. Jen McCabe,
Yeah.
MCC, and I am married with 4 children,
Right.
and I am a soccer mom, and my kids play sports, and I help take care of his niece and nephew, and I am the perfect Canton housewife.
Right.
Hi.
You're funny.
She was ready.
Right. No, I agree. She definitely presented very well today, but I'm prepared for cross because that's really where you see the cracks, right? That's where you get to see the cracks. And hopefully I'd like to believe we get to cross tomorrow, but if we don't, then with this trial that keeps on giving, maybe defense gives us something else to talk about. So yeah, I mean that's my closing. I don't have a real closing other than the fact that you're not going to hear me talk about anybody's guilt or innocence. The closest I've come to that was, I believe it was Allie that actually asked me this question during the YSL trial. I believe she asked if I thought they were guilty or not, and the closest I came to that, I said I was not worried about. Said I was not worried about. What's the other guy? There were 2 left.
Well, it
Not
was,
SB. Yak.
Yak Gotti. Yak
Right.
Gotti. Yeah.
When it came to Yak Gotti, I pretty much said that I was not worried about him, but that's me
Mhm.
saying that I did not believe that the prosecution had enough to get a conviction on him. So that's the
Yeah.
closest you'll hear me.
And you were right. The one guilty verdict they got, or guilty for SB, was connected to, and they even said that, of course, Taisha put the gun in his hand. She
Yeah.
bought the gun, and that's her boyfriend, and obviously there's no other way around it. So that's they were able to get at least a guilty on that one count for him.
Real thing, you need to put some respect on Taisha's name. You have to say Taisha, the prettiest
This
girl
girl.
that is ever dated.
Listen, I don't want no problems. I don't want no smoke.
So yeah, but
He's
again,
a
that just
married man, so let's
yeah,
respect their marriage.
I know, I know. I cannot help
but
myself.
but yeah, she
So,
no.
yeah,
I respect to Taisha. Yes.
yeah. But just my final comment on the whole Taisha and the SB, that part of the conviction. One thing you guys will hear me say over and over again: people underestimate the power of an impartial jury because those folks were tired. All right, they
Mhm.
were snatched away from their lives for almost a year. And even though they were inconvenienced, they looked at the evidence without, any reservations, and they figured, or actually came to a unanimous decision that the prosecution proved that one count. So that's where,
After all of that.
right. So real thing, you get the final word.
Good night. See
All
you
right,
next
there we
time.
go. All right, good night, folks. A real thing, shout out to you. I absolutely enjoyed having you up here. As everybody said, I absolutely enjoyed your commentary. And shout out
Oh,
to
thank
everybody else
you.
that
Thank
showed
you.
up. Yeah, you're welcome. You're welcome. Like I absolutely, it kind of feels like the old times, right?
It does. And I
Very
always learn
engaging.
so much. I always learn
What's
so
that?
much. I said I always learn so much. Like,
Oh,
oh, I
thank
didn't
you.
think of that. I didn't know that. Wow, that's a different perspective. Thank
Thank
you.
you. Absolutely, you're welcome. And I mean, even as I watch, I learn different things as well. I've said over and over again, I'm taking Brandon's style of, uh, a beginning redirect where the cross ended. I think that's brilliant. It works. And I mean, I'm learning through these people as well as I'm watching these trials because a lot of these attorneys do have good insights, and some of their techniques are better than what I've been doing. So, I think it's a win-win.
We're all learning.
Yep. All right. Shout out to Brooklyn. Shout out to Brooklyn. Shout out to Benji, Ellie, Real Thing. Shout out to Fever, Jerome, Callie. Shout out to Sarah. It's been a while since I said that. So, shout out to Sarah and the replay crew. All right, real thing. I'm not going to keep you any longer. You have a good night. And, I hope you guys have a fantastic Wednesday. We will reconvene again here tomorrow, 6:30. Yeah, 6:30 p.m. Eastern time. All right. Good night, folks.